Welcome everyone to the Tonkin Legal Group, home of the Australian Family Law Podcast, the AFLP. Definitely not the official podcast of the Australian Football League. It is I, as always, your boy Joe, joined by St John and Charlie. St John, how are you?
I'm very well, thank you, Joe. Nice to see you guys again.
Absolutely. And Charlie?
G'day, Joe. G'day, St John. Good to see you both. Good to have the three of us on board again. It's been a couple of weeks, I think.
Yeah. No, it's nice, and everyone's enjoying the World Cup in this in this office. So every time I walk past the TV room, someone's yelling "Go!" No, it adds a bit of excitement to the office, doesn't it?
Yeah. Especially
It
with the
does.
penalties now. It's all coming down to penalties and
Yeah,
making me
exciting stuff.
question the integrity of this competition, because some of these misses are quite remarkable, Charlie, isn't it right?
They have been. We saw there was a few penalties this morning in one of the games we were watching where I think if there was a goal above the goal, he still would have missed it. So I think you made a few comments of corruption, Joe, that that I think we'll let slip. But yeah, there was it makes it more interesting when it goes to penalties, that's for sure.
Yeah. Now, listen, we were going to do things differently today, weren't we, Joe and Charlie? We were going to start with a family law premise and then link that to a football premise. So, and what one of the most important questions we're ever asked as family lawyers is, how do I distribute the matrimonial assets upon the breakdown of a relationship? What's the process? What do family lawyers need to tell their clients? What does the court need to do in these circumstances if the court's involved? And there is some conjecture amongst the legal fraternity whether it's a 4-step process, a 5-step process, but generally we refer to a 4-step process when we're asked these questions by clients. So if you have, let's say, $500,000 to distribute, who and how much does each party get? Then the court is bound by the Family Law Act to put into place a process that is a 4-step process, which we'll go with today. And that is pretty simply identify the assets, look at the contributions, i.e. how those assets came into the relationship. Thirdly, look at each party's future needs. And finally, the court really can't make an order, or legal advice really can't be complete without assessing whether the outcome, having looked at steps 1, 2, and 3, are just and equitable. So that's the rough outline, Joe. Where do we usually get problems in the first step, which is identifying the assets?
Oh, it always comes down to, I mean, it's known, and we don't expect clients when they first walk through the door to know and be across absolutely everything. A lot of circumstances we see where it might be that one party is in control of the finances and the other party sort of left in the dark quite a bit, and trusts, because that's what you do. What's a relationship if it's not built on trust? And obviously you're trusting that your significant other is doing what's best for the family, and you're simply trusting, and we got into this point. So identifying what the asset pool is and what is there for division, in a lot of instances, right from the get-go, there's a lot of question marks. What are things, what is there, and what are they worth? And when it comes to things like what is there and what are they worth, that's where the duty of disclosure comes in, and both parties have an obligation to exchange their documents, whether it be their bank statements, whether it be their tax returns, that get their current superannuation balances. These are things that need to be exchanged so that both parties can know what the financial circumstances of each other are, and where there are things that are uncertain, such as what is our house worth, or what are these cars worth. Well, in the absence of any agreement,
do we need to get
as to what they
valuations
are?
done?
Correct.
Yep.
Exactly.
I guess another part of the working out what's in the asset pool is, or part of what we do is we advise clients that the property that can be considered available for division is the property that exists at the time the parties are trying to resolve the matter. So clients might think, oh, what happens after separation doesn't matter. It's just the assets we had at the date we separated. Not the case. It's any assets acquired or liabilities that are accrued post-separation can be taken into account for the purposes of identifying the asset pool. So it's the net asset pool. So assets minus the liabilities, obviously including the parties' superannuation, is what we're trying to identify in that first step of the 4-step process.
And sometimes it can be a lengthy process, can't it? Because the greater the size of the pool, if there are investment properties or family trusts or companies or other assets like cryptocurrency, it can be really hard to ascertain the value of those items or their existence. So I say to clients, bear with us. One of the crucial steps in any family law settlement is working out what the size of the pool is, because that will then dictate how it's distributed. So let's assume for today's purposes, we know what the assets are, we know what the liabilities are, and we know what superannuation is. The next step, Charlie, is about contributions. So can you tell us a little bit about, the timing of contributions and the type of contributions that lawyers are looking for and that the court ultimately are looking for in a distribution of matrimonial assets?
Yeah, well, I guess when we talk about contributions, firstly, we address 3 separate phases. So initially, we look at what was brought in at the very beginning, or what contributions the parties made as at the beginning of the relationship or the beginning of cohabitation. The next phase is what different contributions did the parties make throughout the relationship. And then in the event of separation, and there has been a period of time from separation to the point where the clients come to see us, we then look at what different contributions were made post separation. And as we know, there's a number of different types of contributions. There's the obvious one. There's the direct financial contribution. Who was earning most money during the relationship, who was paying the mortgage. Otherwise, there's other types. So there's non-financial contributions, which can include any improvements or renovations that the parties may have made towards the matrimonial or the family home. And then, of course, there's the homemaker and parenting contribution in the event that there are children of the relationship. So, who was the primary carer of the children, who, I guess, dropped the children off at school, responsible for extracurricular activities, preparing meals, cleaning, those sorts of things. They're the key types of contributions that we go through with clients that can actually have an impact on what that party's entitlement is.
And crucially, the parenting and homemaker role is, in most cases, given equal weight to the primary income earner contribution. So people who take on the very important role of parenting and keeping the home fires burning, that contribution is deemed by the court as equal to a contribution made by someone who goes out and earns an income to benefit the family. Now, there are some cases where that may not be the case, but in most of the cases, that homemaker and parenting role is extremely well considered and given equal weight. Joe, I'm going to ask you to have a quick chat to the podcast listeners about the final step. So we've worked out how much money there is. We've worked out how the money got there by assessing contributions, and we've looked at future needs. No, we haven't yet, have we? Now,
No.
our third step, I'm going to turn to Joe now. Future needs, Joe. What are we looking at when we're advising clients about future needs?
Yeah, as you say, it's the first step is the present. Step 2 is talking about how it got here. So we're looking at it as an assessment of the past. But then with the third step, you're looking towards the future, looking at who is in greater need of the money moving forward. And the Act sets out a number of different factors that need to be considered in relation to whether or not someone is in a materially financially worse off position than the other, requiring a further adjustment in their favour. Some of the classic hallmark examples of future needs factors could be that they are the primary carer of children. Children are very expensive. As you know, having children of your own, and they are almost like a black hole of in terms of the expenses
No
never
comment.
end. Whether or not you've got there's an income earning discrepancy, for example, between the parties, where one party is earning significantly more than the other, they'll certainly be able to rebound and move on with the next chapter of their life a lot easier. Is one party suffering from various health issues, which affects their ability to work and therefore impacts their ability to sustain themselves, whether or not someone is really close to retirement, for example. They don't have a lot of years left to work, and compared to the other party who might have 10 years plus. So substantially there, so that obviously impacts on the next steps in their life. So these are some of the hallmark examples of various considerations and factors that parties are, or solicitors would be turning their minds to when it comes to determining whether there should be a further adjustment in that party's favour.
It's an important step, and it's one, I think, step 2 about contributions and step 3 future needs assessment. They're the ones where we have a lot of disagreements in either the court or in our day-to-day lives when we're battling for our client to ensure that their adequate contributions are recognised and their future needs are recognised. The final step, which is a bit airy-fairy, step number 4, which is the just and equitable step. Now, as I say to any client, what I think is just and equitable may not be what you think is just and equitable. It may not be what Charlie thinks is just and equitable or what Joe thinks is just and equitable. It is a really esoteric concept to get your mind around. But in reality, if each party isn't adequately looked after through steps 1, 2, and 3, then there's an opportunity to again adjust or reassess the asset pool distribution at step 4 to ensure that it is just and equitable. Any guys, you can think of an example where that might play out?
Well, I guess the courts would always look for any outside factors to result in an adjustment to the property settlement.
Yeah.
So, for example, for longer term relationships, it's generally, I guess we look at future needs more so as opposed to those contributions. The longer the relationship is, the time tends to dilute those initial contributions, and we take a greater focus on, well, what are the parties' future needs? What are their current financial circumstances? Are they closer to retirement? So it really it varies depending on the facts. And then on the flip side, for shorter relationships, there would be a greater emphasis on those contributions that were made throughout that short relationship. There's always going to be exceptions. So if there is a young child for the shorter relationship, then obviously that's a future needs consideration. Who has the care of the child. But yeah, as you suggested, St. John, it's family laws. It's a very discretionary jurisdiction. So what one person thinks is fair, another might not think is as fair. So that's kind of, they're the factors that we sort of look towards.
One thing I think the court does take into account from time to time is the monetary value of the outcome. So if for some reason somebody ends up with $500,000 in super, but you can't do anything with it, and the other party's got $500,000 worth of liquid assets, that's not just and equitable. So that might involve a super split from one party to the other, and the other party paying some cash to the person who's keeping some of their super. So that's where an adjustment can be made based on justice and equity, to ensure that where possible, the both parties walk away, well, I wouldn't say happy, but both parties walk away knowing that there's been a process that's been methodically followed, and an adjustment at the end if there's still an inequity. Now, Joe, the court has a 4-step process. Do footy clubs have a 4-step process? What's the secret?
We say
What's the
yes.
4-step secret to success in a footy club?
Well, Essendon Football Club, if you're watching this, and you should be watching this if you're the Essendon Football Club at the moment.
I'll be watching.
Yeah, watching, and those with ears, please listen. These are the 4 things that you need for a successful football club. Number 1, you need to have a good, healthy culture, a culture that is centered around growth, a culture that is centered not around just being nice buddies. It's a professional environment where you're each striving for the ultimate success, and you're all pulling together. So you need to have good culture.
No,
Number
Mr.
2,
Dank.
no, please, SH. I was
Sorry.
going well. Oh,
Sorry,
He's thrown
I
him.
sidetracked you. Yeah, I sidetracked you. So my apologies.
I need a support worker now. All right, then. Number 2. All right. So number 1, good culture. Not like what you just saw then, right? That was bullying. No, I'm just joking. Number 1, you need culture. Number 2, you need to have the right coaching panel, not just the head coach in Hurdy we trust, but also the right assistants as well. You need to have alignment across the board. Everyone understands where they're supposed to be at all points in time. The line coaches are across everything. You then need to have good list management and recruiting, identifying areas of need, where you're deficient in your side, where you can try and poach players from other teams that fill that need to improve the caliber of your side. It also means being able to make difficult, tough list calls. Is a player going to make it? No. Thank you for your services. 4th, and this is something that has absolutely evaded the Essendon Football Club for as long as I've been alive. Luck. You need good luck. Luck for yourself in terms of your injury management. Luck in the opposition that you come against. If they're healthy, when you play your opposition is almost as important as who you play. You'd certainly love to be playing Carlton at the start of this year as opposed to the end of the year. Now, I could say Richmond played against Carlton at the start of the year, but I'm not going to say that. I could say Tom Lynch could have kicked straight, but I'm not going to say that either. So
is that bad luck?
It's
Yeah,
bad luck.
Yeah. Bloody Lynchy.
Those are the 4 things for a successful football team.
Yeah, I think you've nailed it, Joe. I think if every team could put that methodical process into place, they'd be world beaters.
Definitely not peaking too soon as well forms part of it. So I think the Swans this year I don't want to speak too early, but the Swans may have peaked too soon. They may not have timed their run, and I think Brisbane
and now
are
Marty's
timing their
gone.
run.
So.
Yeah, I saw that.
What about Freo? What about Fremantle?
Well,
you don't think Fremantle have peaked yet?
They're just a juggernaut. Nothing's going to stop them this year.
Yeah, I don't think they've peaked.
No,
I don't think they've peaked.
No.
I think there's a lot of room for movement there. The Bolton's been quiet, and he's been great, but he's got another gear.
Yeah. What about your doggies, SH? Are they're waiting to peak at the right time? I think.
Well, I think if they can get Skinny Darcy back, we'll be in a better position. But I don't know. I think they're a little light on down back. I have to confess. Yeah.
And you'll be better with Butters next year.
With who? Sorry.
Zach Butters.
Oh yeah. Well, the Tigers will be better with Zach, you mean?
Well, I heard that they're the 3 in the 3 clubs that are right up there for his services. The Tigers offering the most money, which we've covered on a previous podcast. Joe will put the link to that one in the comments.
That's point number 3: list management, recruiting.
List management. Yep.
Nah, the Butters to the Dogs is the worst kept secret since Bailey Smith went to Geelong. Everyone knew that was happening, and I'm pretty sure it even came. What does he offer? The Bulldogs.
What does he offer the Doggies? They've got 7 players, not of his caliber, but they don't need another midfielder. They need a full back.
Yeah,
Butters
he'd be
is that
handy
good.
though. He'd be handy. He'd be pretty, and he'll extend Bont's career as well. Bont could go forward.
Got to get the
I
ball
think
forward for a start. I'm all about defense.
Yeah.
Well, Libba can't be
Oh,
stick. Well, Libba can't be
True.
moving
Yeah,
forward.
he's must be on his way out shortly. But look, you know, he'd fit into any team. He's a great player. He's probably
Yeah.
the best player in the league at the moment. But in reality, is it a need they have? Or you just take the best
Well,
player.
Can never have
that's why
too
the
much
Bulldogs.
talent.
You can never have too much talent. True,
You
but that's
can always
also
try him down back as well.
well,
Butters to fullback.
that's a question. That's a question for the Bulldogs and for Bevo, and whether or
Yeah.
not the Western Bulldogs are ticking off all 4 of those points in the 4-step process. That's entirely up to them. I know the Bombers certainly aren't ticking any of those, but we'll move on. We'll move on. Hope everyone enjoyed what they had to see or hear from us today. If they did, I hope they like and subscribe, hit the notification bell to not miss out on any of the episodes that we continue to pump out on a regular basis. And if they are listening to us on Spotify, we hope that they rate us 5 stars so that our podcast can continue to spread out and help the lay people out there learn more about family law in a bit more of a light-hearted sort of environment, whilst also giving them a lot of juicy information. St. John and Charlie, it's always a pleasure to have you on, and we look forward to seeing you in the next one.
Thank you, Joe. Thank you, Charlie.
Thanks, Joe. Thanks, SH.
Come on, Hurdy.